All right, so Jim, the question we're answering today is like, how long should a DUI case take? First, we're gonna have to put some parameters on this, right? Like, we're only talking about Illinois. I'm only licensed in Illinois. How about you?
Only Illinois.
So I have no idea what it takes in any other state. Also, generally speaking, a felony is going to be longer than a misdemeanor, right?
Absolutely. Absolutely. But I mean, yeah, I think just like everybody would say this about their kids, every DUI case is special and unique. You know, I mean, I think there's some standard parameters to answer this question. How long should a DUI case take? You know, I think it also depends on what county you're practicing in.
Yes.
You know, was there an accident involved? Were there witnesses involved? Did you go to a hospital? There's a million different things, but I think we can sketch out some general guidelines here for this video.
Yep.
Yeah.
What do you tell clients for like a first time misdemeanor DUI in Illinois? You know, you want to try to do your best to set their expectations. What do you tell them?
I'm saying 6 to 12 months.
Yeah.
You know, unless there's something that's really extraordinary about a case, I think that most DUIs can wrap up, you know, with the conclusion in 6 to 12 months. You know, I think there's a lot of steps along the way. And, you know, there's a lot of things that we do at DDT that we do really well, you know, and sometimes it's a matter of, you know, putting the time into a case to get the best outcomes, which is my philosophy on these.
Yep. I would say all the things you mentioned are big factors or variables when determining how long a case is going to go, right? But a big one is the posture of the case. Are we going to trial or are we not? Because every case gets resolved, I mean, generally speaking here, right? Every case gets resolved in sort of one of two ways. There's either some litigation, think like a trial, and we're arguing in front of the judge with witnesses and all that stuff, or we're reaching some sort of agreement. An agreement typically is faster, right? It's the prosecutor and the defense agreeing on, hey, this works. Our client obviously has to agree to that as well. The judge has to agree to that as well. But on a fairly straightforward, you know, case, that agreement can, you know, if that's what we want to do, then we can usually reach some sort of agreement. Yeah,
and you know, I mean, I think starting for the rough outline here, I mean, the first point, and it goes to your point, Derek, the posture of the case, you know, you're looking for your attorney, you hire an attorney. Here at DDT, you know, when a client hires us, right away we're working on all the paperwork, especially for a first time, for any DUI. We're working on that paperwork, which is our appearance, which is letting the prosecutor and the judge, the court know that we're the team that's going to be working on this case. We're filing a motion for discovery, asking for the police reports, the squad videos, the body camera videos. We're filing a lot of times a petition to rescind where we're trying to get our clients' driving privileges back. There's a lot that goes into, first of all, hiring, and then boom, we're right at work for you right away. I would agree with all that. And, you know, sometimes, I mean, we've had cases where we get videos and police reports and stuff within a day or so of filing. There's other ones where, especially on a felony, you'll go 6 months and you still don't have everything. So that's a big factor, is how long it takes to get all the evidence. You really, you know, from a defense attorney's perspective, we probably shouldn't be making any real concrete decisions on which way we want to go with this case until we've had the opportunity to review all the evidence, right? I mean, it just makes sense, right? You don't want to make these decisions prematurely, so we got to get it all, and sometimes that can be a waiting game. What are some other things that may delay the length of a case? Well, you know, sometimes in the early stages of a case, I like to tell clients that we might be coming back quite a bit in the early stage. And really the reason why is that petition to rescind hearing. The state's attorney, they have 30 days to put on that petition to rescind hearing. And, you know, depending on what county you're in, they really take that 30 days and they'll grind it down to the stuff. You know, some days it's the 30th day we're coming back. And what I mean by that, when a client has to come back a lot, is because that prosecutor, village prosecutor, state's attorney, they can be asking you to come back. Can you come back next week? I'll have my officer here to testify. I'll have all the discovery to you. And, you know, if you want to keep running that 30-day clock down, you got to say yes. Because otherwise you go by agreement. which means yourself and the prosecutor agree to the continuance, and that doesn't run their 30-day clock down,
Right.
which is frustrating in that initial stage of a DUI. But then, depending on what the posture of the case is, we can make those court dates a little bit longer, which I try to do for my clients.
Yep. So, number of different factors that can determine whether a case goes, 6 months or multiple years, right? So let's kind of go through chronologically. One thing that can just take a case out for a while is hire an attorney. Like, we have some people that will call us the next morning. Some we have people that call us while they're on the scene of a DUI arrest, right? Like, I like that. They're snappy, they're quick, they're ready to deal with this. We have other people that just delay months and months and months. They show up to court by themselves and they say, "Judge, I'm going to hire somebody. I just need another month." And the judge gives it to them. So some people just drag their feet in hiring an attorney. But once they do at least hire us, what is it we do?
I mean, right away we get to work. We're filing all the paperwork, and that's a lot of paperwork. That's our appearance, which is letting the prosecutor and the judge know, hey, our team is on this case. It's filing a motion for discovery, and people ask, what's discovery? Police reports, squad videos, body camera videos, any civilian videos or witness statements, hospital records if that's relevant to the case. We're filing what's called a petition to rescind, which is asking for our client's driving privileges back.
Yep.
It's important that we file that right away because it starts a clock that we'll talk about in a little bit. We're filing all these things right away when a client hires us to get the process rolling, hopefully as quick as possible.
Yep, and sending subpoenas
Yep.
to try to get it, because we don't know what exists, right? Like, we weren't on the scene, so we just have our client's story. I don't know what documents and videos exist and what don't, and so we have to kind of start very broad and try to get all that and start to fill in the blanks. And sometimes that could take, once in a while it's all buttoned up, ready to go, and we get it within a day of filing. But more often than not, especially in some bigger counties, like Cook County, which shall remain nameless, it can take forever, right? Especially in the more serious case, the more documents, the more medical, so that's a big factor is how long does it take to get the discovery? Another one is that you mentioned a statutory summary suspension. Walk me through that a little bit.
Yeah, so right away when a client hires, one of the first things we're doing is filing that petition to rescind a statutory summary suspension. That's where our client, if we're talking about a first-time DUI here, where their license is either going to be suspended for 6 months or a year, depending on if they gave a breath sample and what it was. So right then, when we file that petition to rescind to get our client's driving privileges back, it starts a clock, a 30-day clock on the prosecutor's office to put on that hearing.
Yep.
So that's why we file it right away to start that clock. But I tell a lot of clients, at least in the initial stage of a DUI case, we might be going back and forth to court a lot,
Yep.
more than I'd like to. But that's the nature of the beast here early on in a DUI, where that 30 days the prosecutor might say, hey, it's Monday, can you come back next Monday? I'll have the police officer ready for you.
Yep.
I'll have the police reports and video. And you kind of got to sigh and say yes, because otherwise we're agreeing to a continuance, and that pauses that 30-day clock.
Yep.
So in the early stages, you might be bouncing back and forth a little bit, but that seems to smooth out in my experience.
But it's all in the name, and in most cases, we're looking to save people's driver's license, and it's all in the name of saving the driver's license.
Exactly.
Most of our clients would be happy to go to court, 2 or 3 times in the beginning if it means the difference between them being able to drive and not drive. And so that can, certainly be a bit of a delay as well, and something we have to work through. Another one would be like drug and alcohol evaluations. There's no surprise that those come part and parcel with having a DUI, doing an evaluation. That can take some time to go do it, get the evaluation back, get it submitted to the court, make sure it's, from a defense attorney's perspective, we want to look over it, make sure it's accurate, there's nothing wrong with it. So that can be a big delay. Also, how about treatment? Sometimes we'll have our clients do drug and alcohol treatment before we even want to resolve the case, right?
Yeah, in fact, there's some courthouses throughout Illinois where they won't even think about reducing a DUI until they see your treatment being submitted. So what I mean by reducing a DUI is on occasion there'll be cases where it makes sense based on our conversations with our clients and our knowledge and experience to ask the prosecutor to maybe reduce a DUI to something like a reckless driving.
Right.
In one of my courthouses that I go to frequently, they want all the treatment done up front.
Yep.
Another thing that I want to throw in about treatment that I like doing is I like to meet with all of my clients and prep them for these DUI evaluations.
Yes.
I mean, and that can delay it too, because I like to really have a solid foundation so that they know when they go into this evaluation, they don't feel like they're walking into something that they haven't heard anything
Right.
about, that they're going to be giving answers that might actually hurt them in the long run.
Yep.
I found that those have been really helpful conversations with clients. I mean, it's something that I like about DDT. I like a lot about us, but I really like that we try to put the clients first when it comes to these.
Yep. Makes sense. And then, again, we can keep going with this. There's a lot of different things, but the biggest is the posture of the case. And are we going to reach some sort of an agreement, which generally speaking can be done quicker than going to trial. And trial can take a while because you've got police officers' schedules, prosecutors, defendants, attorneys' schedules, even judges. I mean, Judges say, no, I'm on vacation that week. Can't do it. Let's go to the next month, right? So you got to kind of coordinate all those people for a trial. And that's just one of the reasons it can take so long. Of course, there can be sort of pretrial hearings and motions and stuff that go on and even getting to trial. But yeah, on average, our cases, misdemeanor first-time DUIs, take about 8 months. Sometimes clients are shocked to hear that. They're like, well, it's just a traffic ticket. No. In Illinois, it's a criminal offense. And when you take all those ones that take years and go to trial and blend them with those ones that, you do reach an agreement on average, knowing nothing about your case other than it's a first-time misdemeanor DUI that we handle, I tell you, it's going to take on average about 8 months. Which is a long time to have that case hanging over your head. And I get it. I mean, people want it done with, and I don't blame them.
Yeah, but what I say is it's better to measure twice and cut once, especially with this too.
Yep.
We want to make sure that we review all of that discovery and really advise and sit down with clients and tell them, in my experience, I think this is a triable case, or I think that you're better off taking this offer. And I mean, a lot of different factors go into that. And, like you were saying, Derek, there's a million schedules to coordinate. It's summer right now. I've been finding that a lot of the times when I've been trying to set it for trial, the officer's on vacation.
Right.
We have 6 trials scheduled for that day. So, that, like you said, that can add a month or two, and that's really out of our control.
Yep.
So.
At least here in Illinois, there is no predetermined outcome for a DUI. You are innocent until proven guilty, and then it's a question of whether or not the prosecution can prove you guilty. And similarly, there is no predetermined timeline. They didn't say, within the first 30 days, you got to wrap this up. No, there's a whole bunch of little timelines that can be moved within there, and that's why you get that large range of just how long a case may take. Hope that gives you a little bit of clarity if you are facing a DUI here in Illinois. Again, our theory at least is to, I like the way you put it, measure twice, cut once. Another way of saying that is to, I don't care how long it takes, let's make sure we're getting you the best possible outcome. Thanks for watching.